Well, greetings. Bill O'Leary coming at you today to answer the question, the attorney ethical obligations in elder law. You know, it's a great question, and it's one that really is very important when dealing with clients that have an elder law issue. So in this video, I'm going to talk about the ethical issues that an attorney has to deal with in elder law. Now, first, let me introduce myself to you. I'm an experienced elder law and estate planning lawyer in Jacksonville, Florida. My firm is Legacy Planning, a law group. We focus on just a few areas of the law. Things like elder law, which again, it's in essence, it's estate planning for seniors. Estate planning, things like wills, trusts, and estates, and probate and trust administration after somebody, a loved one has passed away. That's all we do. So we do a lot of that. So let's get right to the topic at hand. You know, there are a number of ethical questions or issues that come up in the practice of elder law, and it's important that the attorney understands these issues and addresses them correctly. I just want to focus on three ethical issues in particular. The first is identifying the client. Now, you may think, well, that's easy. That's a no-brainer. That's the person that calls your office, right? Or that's the person that comes into your office. But it's not always that obvious. The person that comes into your office may or may not be your client. So asking the question, who is your client, is an important initial question to get answered. Why? Because it's the client and only the client to whom the attorney owes important legal duties, like duties to be diligent and loyal and duty to communicate and so forth. So, you know, in a situation where there are two or more people involved, like a parent and a child, sometimes the lines can get blurred. So the attorney has to figure out who the client is. Is it the parent or the child? So let's say the client is the parent. The attorney should make clear to everyone, especially if parent and child show up at a meeting, that the client is the parent, not the child. The attorney also should ask the parent if, hey, will you let me talk with your child? Most of the time, this is a non-issue, of course, but sometimes it can get a little tricky. The second ethical issue is a confidentiality. So in elder law, confidentiality is very important. Anything the client tells the lawyer is confidential, is covered by what we call the attorney-client privilege. Again, with a parent and child situation where the parent is the client, the attorney has to get the parent's consent to share information with the child. So, you know, the child who may be heavily involved in let's say, mom or dad's affairs, sometimes they may think that they're the client too. The attorney has to set clear boundaries and make clear that they don't represent the child and that whatever mom or dad tells them is confidential unless mom or dad authorizes their disclosure to the child. By the way, the attorney may also want to meet with the parent privately if they come to a meeting with child, maybe ask child to sit out in the waiting area for a while. And that's to assess a couple of things. One, to assess mom or dad's capacity, mental cognition, and two, to find out if there might be some possible undue influence going on that child may be exerting over parent. Now, the sticky part comes up where the attorney may be representing two people, think spouses, okay? So the attorney in a joint representation like that is not allowed to keep secrets. So if one spouse shares information privately with the attorney makes it clear at the beginning, I'm allowed, in fact, I'm duty bound to share that information with the other spouse. And so if one spouse shares information with me but says, don't tell the other spouse, then at that point, basically, I have no choice but to withdraw from representing both of you. Third issue, ethical issue, is I've alluded to it, client capacity. So it's whether the client has the legal capacity to even retain the lawyer, to hire them, and engage in the planning that's being discussed. So the attorney needs to consider and evaluate things like, what's the client's state of mind? Does the client have the ability to sort of understand the consequences of their actions and articulate the reasons for taking those actions? Do they understand the type of decision that they're making? And the client needs to consider, okay, is this a decision that can be easily changed or reversed? Well, that's one thing. But is it irreversible? Well, that's another matter altogether. The attorney also should distinguish between incapacity and the inability to remember, maybe memory that may be failing. The fact that a client does not remember a decision does not mean that the client did not have the capacity to make that decision at the time that it was made. Sometimes that line is difficult to distinguish. So if you'd like to know more about the attorney ethical obligations in elder law and maybe how we can help, we would love to talk to you. We make it very easy. We invite you to take a sort of a baby first step to schedule a 15-minute phone call. It's called our discovery call, and it's free. And it's a chance for you to tell us what's on your mind so we can tell you if we can help you and for us to start to figure out if we'd be a good fit for each other. So again, as I said, we make it very easy. We encourage you to go to our website, Legacy Planning Law Group, legacyplanninglawgroup.com, and go to the book your free call button now, and that'll take you straight to our booking calendar. Just pick a date and time that work for you. So this is Bill O'Leary signing off for now, and until we talk again, go make it a great day and a better world.